And you should probably see the little disclaimer about the recording right now. Okay, great. Okay, so we'll get started. And again, we are with the Public Protection Cabinet Department of Financial Institutions. This is not advancing. Okay, guess I have to do it that way. Technology problems. You'd think by now we wouldn't have to deal with this, but we do. So this is the Division of Securities Educational Webinar for Investment Advisor Law Changes. So we'll start off with the introduction of those that are here today, and then we will move into business continuity planning, and then cybersecurity. And then lastly, we'll talk about that investment advisor representative continuing education. And then we'll touch on the frequently asked questions at the end. And as I did mention, we will try to allow some time at the end for questions. If you do want to ask a question, you can do so, or you can just drop that in the chat, whichever way is going to work for you when we get to the end. So I'll start off. My name is Marty Gibson, and I'm the acting deputy commissioner, and I'm also the securities administrator. To my right, I have Lindsay Stout. She is our compliance branch manager. And then on the other side of her is Chad Harlan. He is our enforcement branch manager. And then to my right is Anthony Murphy, and he is our registration branch manager. So we're each going to talk a little bit about a section. And again, as I mentioned earlier, we do have some resources for you at the end. And then Lindsay and I've included an email address for Lindsay and myself, and we will be specific contacts for you on some of the subject matters. And so just to give you a little preface, for some of you that may not know, Senate Bill 298 was passed in the 2022 legislative session. You can go back and you can still read that bill online, but we have now incorporated those into 2 different statutes. And then we'll talk about those changes, and we'll talk specifically about those statutes. We did implement new requirements for investment advisors as well as investment advisor representatives. The investment advisor changes deal with cybersecurity plans, as well as business continuity and succession planning. The investment advisor representative section focuses specifically on the continuing education piece that I'm sure you've heard about across the country. And this is something that we were able to pass in Kentucky, and more states are on board for that as well. So this is something that you'll probably see across the country. And we'll talk a little bit about that more later. And the effective date for these is January 1st, 2023. Normally, whenever a bill is passed and it is incorporated into statute, that usually happens around July 1st of that same year. But we did push this off to January 1st, 2023 to allow time for compliance and for the continuing education piece to flow effectively. And you'll kind of see some of that as we get into the specifics later. So all this will begin in 2023. Now I'm going to turn it over to Lindsay to talk about business continuity and succession planning.
Good morning. I hope you've all had your morning coffee and ready to dive into this. First, we're going to talk about business continuity and succession planning, which is outlined in Section 5 of the statute. It specifies the requirement for written procedures relating to business continuity and succession plan. So specifically, what the plan must include, it's going to take into consideration the facts and circumstances of the investment advisor's business model, the size of your firm, the types of services you offer, and the number of locations. So I know for a lot of our investment advisors, you may just be a single member LLC. You don't have other employees or registered people. Your plan is going to look a little different from an advisor with multiple representatives in other locations. So for those who have multiple people, you're going to need to outline who's going to be responsible for the oversight and implementation of your plan. Obviously, there's going to probably be more than one person that's going to be looking at this and responsible for the implementation. You need to look at the different ways that your business could be disrupted, whether it could be a natural disaster. We've had a lot of tornadoes and floods in recent times. versus potential cyber attacks or the death or disability of the key personnel of the firm. So if you're a single member LLC, you're disabled down and out for a while, you need to have a backup plan for who can step in and help either continue the operations of your business or wind the business down on your behalf. So looking at business disruptions, how that could impact your firm, you're obviously going to have to think of what potential harm this could cause to clients if the sole member is not available. Other office locations that you would be able to operate from in the event that your primary office is no longer habitable, where you would serve as a backup for contact with clients and servicing accounts. And then how this could also impact access to custodians, third-party vendors, and service providers. So just some key points to think on there. Other things that the plan must include. At a minimum, it should detail how the firm is going to protect, backup, and recover its books and records. So again, a natural disaster, if you had a tornado that completely demolished your business, where will you be able to access the backup of all your books and records? I know a lot of firms sometimes want to rely on their custodians, and the custodians do have account applications and anything related to the specific accounts, but your custodian will not have a backup of your financial records, of every client's advisory contract and correspondence, things of that nature. So you may have various ways you're backing up data or different vendors, but you need to outline that in your plan, where and how it's backed up, the contact information for those vendors. And obviously an offsite location is highly recommended in the event of some full, disaster that you would no longer have access to your main office or potentially your computer. So you also have to ensure that you outline alternate means of communications with clients, your personnel, service providers, custodians, and the regulators, us, or the SEC if you're an SEC covered advisor. So you will need to notify all of us, clients, your employees, us, of any significant business disruption. If your primary compliance officer or person overseeing your business becomes deceased or disabled, or any potential disruption to your services, you need to have a way to notify both clients, us, and all the related parties. So you need to take into consideration, what a total loss versus a temporary loss of your business may entail. What controls are in place for accessing that backup data without your key personnel? Are there other people within the firm or outside of the firm that you are going to allow to have access to that data, and making sure that it's properly protected? But who and how will they access that data? And that data will maybe change over time, so it needs to be current when they do access it. You'll also need to ensure that you outline an office relocation in the event of a temporary or permanent loss of your principal place of business. So whether it's your primary residence or another office location, where and how the firm will continue to conduct business to be able to service its clients. You'll also need to ensure that you have outlined an assignment of duties to qualified responsible persons in the event of the death or unavailability of your key personnel. So while the statute does not define qualified responsible persons, the division has taken the position that a qualified responsible person needs to either be another registered investment advisor representative who will be able to step in and serve in that role for your clients. Their name and contact information should be outlined in your plan. If you are a sole member LLC and you don't have that additional registered person you can reach out to or haven't formed such a relationship, then you would need to have someone qualified to step in and wind down your business for you. So who would that person be? How would they access your plan? And the necessary people to notify them of your death or disability. And how will they know that the plan is current, that they are accessing? So those things should all be outlined in your plan. And then you'll need to address how service disruptions and client harm, significant business interruptions, how you're going to minimize the disruptions to your clients. So assessing your operational and financial risks, again, identifying key personnel and qualified responsible persons who are going to have access to oversee and help step in to ensure your operations continue smoothly or are wound down. Again, you should have custodian information outlined in your plan, who your custodians are, their contact information, any third-party vendors and service providers that you're using, whether it's accounting firms, legal counsel, compliance consultants, IT service providers that are providing backup of your records. All these parties should be identified so that the appropriate persons can reach out to them in the event that you are no longer able to continue servicing your clients. Also, banks and creditors, any banks and creditors that you have relationships with, and the regulatory authority, which for most of you, obviously your state registered advisor would be us, the Kentucky Department of Financial Institutions. And then lastly, the plan must be reviewed annually, and you have to document that review and maintain evidence of the review of your plan at a minimum for 3 years. So you need to think about who's going to be responsible for that plan review. For anyone that has multiple representatives, maybe it'd be more than one person, how that review is going to be documented and where they're going to maintain evidence of the annual reviews, as well as making sure any qualified responsible persons have access to the current plan in the event of a significant business disruption. So that's basically what the statute says. Obviously, we'll be looking at these during the course of compliance exams, so you don't have to feel the need to go ahead and send all these to us right away. We don't intend to start taking action for firms not having adequate plans in place. We will just address that, during your examination and let you know any areas of improvement that we see there. So lastly, we did post a couple of links for some resources if you're interested in looking at these to help you develop your plan. One is through FINRA, as they have a rule that requires broker dealers to have in place a business continuity and succession plan. So you can look at their guidance, or another one that's a little bit older, but the SEC had published jointly with FINRA and the CFTC that talks about the importance of having such plans in place. So if you have any questions on that, I would be your primary point of contact, and we'll provide my contact information at the end. Thanks.
Thank you, Lindsay. And I do plan to drop both of these kind of in the FAQs at the end when we do post those. So hopefully you'll be able to have these resources. I saw a few people taking screenshots, and that's perfectly fine because that's what I would do as well. But again, we will try to have these available for you also. And I just want to emphasize how important this really is now. And if you look at recent activities and events in Kentucky, we had the massive flooding in eastern Kentucky. We've had all the tornadoes, as Lindsay mentioned, and some of these did come into play for not only investment advisors or in the securities industry, but if you look in the banking industry or some other areas, there were offices that were a total loss. And again, these individuals were unable to access. So that's why it's so important to have this business continuity planning as well as a succession plan so that the operations are able to continue, because as we all know, the importance is our investors and servicing our investors and servicing your clients. So again, it's very important that you do have this in place. As Lindsay mentioned, we don't plan to take action based upon the plans themselves and the content of those plans, but we do expect you to have a plan in place. And even though we understand it could need some changes and some amendments, and when we review those in the course of the exam, then we can make those recommendations, but you should at least have your plans in place in 2023. So with that, I'm going to turn it over to Chad and Anthony to talk about cybersecurity, which is the second piece of the law that was passed in the last year.
Okay, section 6 of the expanded statute requires written physical security and cybersecurity policies and procedures designed to ensure the confidentiality, integrity, and availability of physical electronic records and information. And those policies and procedures shall, number one, be tailored to the advisor's business model, taking into account the size of the firm, types of services provided, and the number of locations. Questions you need to ask is who is responsible for the oversight and implementation and ongoing monitoring of the policies and procedures? How will the firm ensure all employees protect firm data at each office location if you have multiple locations? How will a breach of security or cyber attack impact firm operations? At a minimum, the plan and procedure should protect against reasonably anticipated threats or hazards to the security or integrity of client records and information. It should ensure that the advisor safeguards confidential client records and information and protect any records and information for which the release could result in harm or inconvenience to any client. And they should also cover at least the following 5 functions. First one being identification. Development of organizational understanding to manage information security risk to systems, assets, data, and capabilities. Protection. Development and implementation of appropriate safeguards to ensure delivery of critical infrastructure services. Third, detection. Development and implementation of appropriate activities to identify the occurrence of an information security event. Fourth, response. Development and implementation of appropriate activities to take action regarding a detected information security event. And next is recovery. Development and implementation of appropriate activities to maintain plans for resilience and to restore any capabilities or services that were impaired due to an information security event.
Good morning. Now that we've talked about a little bit of the statute, we'll talk about some of the things we're looking to protect against. Some of those threats include employee access. You need to consider as you make these plans, you're safeguarding data and devices, keeping in mind that while a lot of us think about access from our office, if you're accessing the client information from your computer through your home network, you may need the same considerations in that network. Or if you're visiting clients in person and accessing it through their Wi-Fi, you need to keep in mind the types of safeguards that need to be in place for you to do that, or if you need to use a hotspot instead. You need to utilize encryption and talk about how your company's going to do that. And you need to start looking at requiring strong passwords and how you're going to verify your employees are using those types of strong passwords. You need to limit your access as necessary to confidential and personally identifiable data. Certainly that's different concern for a sole proprietor or a one-man shop versus a firm with lots of representatives. So you need to take into account how that applies to your direct type of business. You need to implement training for employees, new hires, on what types of threats to be aware of. You need to look at your network security, like I said, both in your house or in your office, as well as any other location where you may be accessing information from. Look into information or items such as firewalls, what type of data protection, what type of backups you're using. You need to look at the security on your computer. Are you patching, running all patches, updating your antivirus, running 2-factor authentication? These are types of things you need to look at, make sure you implement, and I will also caution you to think about. Very few people are running antivirus software on your cell phone. So if you do access or communicate with your clients with your cell phone, you need to also be looking at these same considerations for any device where you may be communicating with clients and sharing information. Look at third-party vendor access and who has access. What types of security measures are in place? What risks are implemented by that? And require through your agreement with them that they notify you of any breach that they may be receiving or victim of. You need to perform risk assessments to identify vulnerabilities in your network and look at ways that you can improve that. You need to create an incident response team to review your risk assessments. Keep the firm aware of new risk as they arrive and discuss what the firm is doing to stay on top of risk. And you need to have a strong incident response plan in place to address the firm will respond and recover to any security breach, including notifying the appropriate authorities as well as clients and determine whether or not cyber insurance coverage is appropriate. Finally, as part of the assessment, KRS 292-336 6C says that you also shall annually review your policies and procedures to ensure the adequacy of the security measures and how effective they have been. You need to determine as you're putting your plans together who is responsible for that review and how they will be documented. The review shall be documented as it goes on to explain it, and previous versions shall be kept for at least 3 years. So you need to also discuss in your plan where and how those reviews will be maintained and documented. There's some resources available both through NASA, SEC, and FINRA. They provide some guidance on what you need to be looking at, what kinds of checklists, and what concerns you may be vulnerable to that you need to consider as you put these together. NASA has 89 different areas that you should be looking at. SEC provides periodic cybersecurity risk alerts, news, and information. I think there's one more.
So, sorry. There you go. Sorry.
And the CISA is an agency that provides cyber issue and ransom attack information. You can subscribe to alerts. They have some training and resources on there that you can also review and use that as you're implementing your plan.
We'll just say, we try to stay on top of this and learning more about cybersecurity threats and issues. And this federal government agency, I was amazed at what they offer and provide. If you see the last bullet point on there, they offer free services for all organizations to do vulnerability scanning and testing and phishing testing for your firm to see if you're susceptible or any of your employees are falling for potential threats. So I would highly recommend that you go to their website and look at that, because that could be part of your ongoing review and testing to see if, you have the appropriate measures in place to afford protection to confidential data. Oh, and gone are the days of I have an Apple computer, so I don't need to worry about any viruses. All it takes is one phishing email and the wrong click, and you're vulnerable. So.
Oh, there we go. Oh. Bear with us just a second.
As opposed to attending, get logged out.
Yeah, I got locked out. They call Heather in.
Can anyone hear me? Bear with us just a moment. We got disconnected for some reason. There's a limit on this, so just give us just one moment. We'll be right back.
Wow, I didn't do this.
Oh, you're still there.
Okay. Okay, we're good now. Okay, can everybody hear now? Again, apologies. We don't use this room very often. It's the hearing room and the technology is not very cooperative, so. Again, just let me know in the chat if you can't hear me. Okay, good, thank you. And I just see a few questions that have popped up and I will go back to those at the end. One of those was involving, great question involving the PCP plans. And then another question regarding cell phones and viruses. So we'll go back to those in just a moment. And for now, we are going to go on and touch on the investment advisor representative continuing education. Now, there are quite a few statutes on this one. I did not include every single one of them in the presentation because again, it's pretty early and we would like you to stay awake. But if you do go to 292, KRS 292-338, it does outline all the parameters for this. So I want to go over just a few pieces of information and touch on what's probably going to be most important to those of you on the call. So this does require that you have 12 full credits of continuing education. 6 of those credits must be of ethics and professional responsibility, that content offered by an authorized provider with at least 3 of those hours covering ethics, and 6 credit hours of products and practice content offered by an authorized provider. Now, I'll go ahead and answer one of my questions that will probably be at the end because I know you're seeing authorized provider. So these are firms that have been approved by NASA to provide continuing education. And if you're not aware of NASA, we've mentioned that quite a bit. It's the North American Securities Administrators Association. This is a model rule, which I will talk about that in just a minute. So there are a lot of uniform resources for firms and individuals to use. So again, as you can see, it is a North American Securities Administrators Association model rule. Most of the states that have adopted this, and to date there have been 10, have done this almost uniformly. And if you know anything about any rules that may have been adopted in the past, that's very rare because states have very different rules and laws, even though we're all generally part of the Uniform Act. But in this case, this model rule has been passed very, very similarly in every state. So you do have some limits on that for the state of Kentucky, and I'll explain that in just a moment as well. Okay, so KRS 292-338, Section 5, an investment advisor representative registered or required to be registered in Kentucky who is registered as an investment advisor representative in the individual's home state shall be considered in compliance if certain parameters are met. And what does that mean? That means if Ohio and Kentucky have both passed the investment advisor representative CE requirement and you live in Ohio, but you're registered in Kentucky, we will have considered you to be in compliance. And those parameters at the bottom, that's referencing that Ohio's law is at least as stringent as ours. And I'm just using Ohio as an example, but if you look on the NASA website, you can actually see all the states that have passed this, and I'll give you those resources at the end. So in other words, if you're calling in from another state, or if you're in Kentucky, for example, and you're questioning about, will this work with another state? Yes, it will, as long as there's reciprocity, and that's going to be as long as those are as stringent as the other state. And again, like I mentioned, everyone's passing this generally very, very similarly, so that should not be a problem. An investment advisor representative who fails to comply with this section by the end of a reporting period shall be subject to renewal as CE inactive. The IAR shall remain CE inactive until he or she completes and reports all required CE credits. And an IAR who is CE inactive at the close of the next calendar year shall not be eligible for registration or renewal. So what this means is you essentially have 2 years before anything actually happens in terms of the CE. So if we're in 2023 and you do not do any of your CE in 2023, then you will renew for 2024 as CE inactive. And then you essentially have the rest of that year. If for something happened, let's say you had a family issue, you were unable to complete it, then you would just remain CE inactive. But if at the end of that second year, the second calendar year, you will not be eligible for registration or renewal. So there's a lot of flexibility built into this, but I would encourage you to get those CE credits as soon as possible and complete those by the end of the year. Because if for some reason you do not complete that and you're CE inactive, you still have to complete 2023 and 2024. So just because you miss a year doesn't mean you don't have to complete those credits, because they will all continue to pile up. So the reason that I'm sharing this is I know that some individuals are pretty nervous that you only have 1 year to complete this if you're an individual IAR and maybe aren't affiliated with the broker dealer firm. But again, there's a lot of flexibility and there's a lot of opportunity to get your CE completed. So those are the basic parts of the statute that I wanted to share with you. Again, you can go in and look at that, KRS 292-338. It outlines all the parameters, gives you definitions, pretty much everything that you need in terms of compliance with this. But I did save a lot of this for the frequently asked questions, because for the most part, the questions will really answer what the statute may be unclear. So here's the first question. So my firm is notice filed in Kentucky. Do all our IARs need to complete CE? And the answer to that question is no. And what I want you to remember here is that this is tied to the individual and not the firm. So if you're a firm and you are registered in Illinois and you have 3 reps in Kentucky, those reps do need to complete the CE. However, if you have reps that are only registered in Illinois or other states that are not Kentucky, they do not need to complete that. It is not a firm requirement. It is not firm-wide. It only is based upon the individual. So that answer does answer a lot of the questions that I've received. So in other words, this is tied back to the IAR and not to the firm itself. Now, second question, are IARs required to take specific courses? No, you're not required to take specific courses. There are numerous courses to choose from. You just have to ensure that they do fall into those 2 categories. And you can take courses that may be of interest to you in terms of products or ethics or something that's more interesting than another. But again, they must all be approved to report courses through an approved provider. So who reports course completion? So the provider is supposed to report your course completion. That way, it is reported directly on through CRD, so there should not be much for the IAR to do. However, I encourage both reps and firms to keep up with the courses that you've completed, to double check to make sure that those are reported. So while that is a requirement that it be reported, obviously you want to make sure that those do show up and there hasn't been an error or a problem. So if an IAR earns more than 12 CE credits in a year, can he or she carry those hours over to the next year? The answer to that is no. While I encourage you to get as much CE as you can, if you do complete 20 hours, then only the 12 will be credited. Does an IAR need to make up missed CE credits? And the answer to that question is yes. I referenced that earlier. So if you did not complete your CE in 2023 and in 2024 you complete 12 hours, that's not enough, because your 12 hours has gone back to 2023 and you still would need to complete 2024. So I am registered as a broker-dealer agent with a FINRA member firm. Does my agent CE count towards IAR CE? So the answer to that question is yes, as long as parameters are met. So there is something written into the statute that talks about the FINRA member requirements. And that's just built in for if some reason FINRA completely changes its process, then and those don't suddenly comply, that's why that's in there. But generally, if you are completing CE through your broker dealer agent training, those will apply. But again, you just have to make sure that they meet both the product and the ethics requirement. Who will provide CE that meets the requirements? So again, there's a list of approved providers, and I just want to note that firms can also be approved providers. They just have to submit an application to NASA, and NASA will take a look at that. So it's, again, the NASA website is a huge resource for this, but all those approved providers are listed. You can do those individually. You can go through your firm and you can just talk to any of those individuals. And there are some firms on there as well that are CE providers. And we do expect those numbers to increase and more firms to offer this as more and more states actually adopt the CE requirement. And one question that I've been asked frequently is, can IARs be exempt on the basis of experience or professional designations? Now, the answer to that question is no, because just because you've been in the industry 20 years, you're not exempt. It's number one. And for the second part of that question, let's say that you're a CFP. You're not automatically exempt because of your CFP CE training, or because of your CFP CE. However, some of those courses may actually meet the requirements. And I believe as time progresses on this, some of the providers are starting to say, so this course will work for the requirements of both the certified financial planner as well as for IAR CE. So again, you just really need to look at the courses. It's based upon the courses and based upon the approval. And you just want to make sure that those are on the approved list of providers. But I think, as I have had several firms that have said, or training providers that have said they're going to start doing both of those. So I expect that that will increase as well. I want to give you this resource. So this is the NASA website, and it's, if you want to screenshot anything in terms of IARC, I would do this one. So industry resources, and it goes straight to the investment advisor representative continuing education. There's a list of all the participating jurisdictions. So if you're registered in, obviously, if you're on this, you're probably interested in the Kentucky part, but if you're in another state and you're not registered in Kentucky, or maybe you're a firm and you have reps registered in various states, then take a look at that, and it will tell you the participating jurisdictions as well as the year of implementation. There are only 3 states that had this implemented in 2022. And then, as I said, another 7 start for 2023, and all those are listed on the website. There is a huge FAQ section on there. It goes into a lot more detail and answers a lot of other questions that may not necessarily be as important for what we're talking about today, but it's a very broad scope. And there are resources for firms, for service providers, as well as for IARs yourself. And there are 2 additional webinars that are posted on there. And that's just similar to what we're doing today. They're just providing information and answering questions on the IAR CE. So, and this will answer a couple of questions that I did see come through on the chat. So if you have questions about business continuity and cybersecurity, then you can reach out to Lindsay, and her email address is lindsay.stout@ky.gov. And that is listed on the website. We'll also put our contact information in the FAQs so that you'll have that reference. If you have questions about investment advisor representative continuing education requirements, you can reach out to me individually. And if I can't answer that question, I will certainly find an answer to that question. I've had to do a little research on a few myself, as this is new to us as well as you. So again, marnie.gibson@ky.gov. So that's really the main information that we did want to share. We wanted to allow some time for questions, because I think that that's probably the most important part of this. And again, I'm glad, we're happy to give you the resources, but we want to try to take your questions. I'm going to just look through the chat, and then between the 4 of us, that we'll answer those questions for you. So if you give me just a moment, I'm going to start kind of flipping through the chat. And Lindsay, if you want to kind of.
So yeah, I'll do my best to answer any questions you have about business continuity, succession planning, and cybersecurity. Obviously, I'm not all knowing, so we will collectively work together to get you answers. One question I did see that I thought I would address is, does the continuity and succession plan and cybersecurity policies and procedures have to be incorporated in your compliance manual? And that's no, not all investment advisors have a compliance manual. It's only a requirement if you have more than 2 investment advisor representatives. So for those who don't currently have a compliance manual, they're going to have to separately develop these plans and procedures. But you can certainly incorporate it in your manual if you wish to. So separately or within your compliance manual is permissible as long as you have the plan and procedures detailed.
So Chad, if you can answer this next question, and we only, this one microphone is the only one that does work in this room, so apologies that we're kind of going back and forth. So Chad, could you address about how an iPhone might be infected with a virus?
There are viruses out there on the iOS platform, so they're either Android or iOS are potentially subject to viruses at this point. There are, and certainly it can be used through your email and any connection your iPhone may have to your other data platforms, especially if you connect them directly, to share a virus between the two. So while they're not as common as computer viruses, there are cell phone viruses out there, and it should be something you consider. There is virus protection software out there available for all the major cell phone platforms. Some of it's free, some of it does come with a cost. So it is something to consider looking into, both for your professional communications and your personal phone.
And so Lindsay had the same question regarding the cybersecurity program and the BCP. I'm assuming the answer is going to be the same for your cybersecurity document about being included in policies and procedures.
Yeah, those.
So yes, so the answer to that question will be both.
They can be separate or within.
So they can be separate or within. So one of the questions was, are there screenshots or instructions of how this looks in FINRA and how we can check status? So yes, there are on the webinar, I believe they do go over a few of those, and it's available as soon as your state adopts that. So beginning the very first part of 2023, you should be able to look up your registration and you will be able to see the CE in there. That's something that we can do some screenshots of and we can add to that presentation, but I won't be able to do that until the beginning of 2023 because we only have a test version right now that I can't show, but you will be able to go in yourself and look at that. And I do believe that the the NASA webinar will show some of those CRD screenshots of what that looks like. But I have noted to make sure and include that and update that when the changes are made for 2023. Another question is, can I take CE courses in December of 2022 and use those credits in 2023? Unfortunately, I know no. The answer to that is no. And while I know we're a little downtime maybe at the end of December, that would be a good time. You cannot do that. It does have to be after January 1st. Let's see. So another question is for clarity. Are we required to complete 12 hours per year or every other year? So that is every year. So I appreciate that question. So I use that as an example as 2023 and 2024, but yes, you are required to complete 12 hours every calendar year. So what information do we need to give to CE providers in order for them to report the CE to the state of Kentucky? So that's actually not necessary. And that's why this is a great program that was implemented. This is all reported through FINRA and the CRD system. So you don't have to report anything individually to us. we will be able to take a look at CRD and get that information ourselves. And we're working very closely with FINRA and with NASA to ensure that that happens. So there's no extra steps for you. You just want to check and make sure that it is reporting under your record. So if you take a look at your record and you see that you've taken 9 course hours and there's only 6 up there, you'll just want to check and see, you know, where that problem might be. But generally, this has been in the works for quite some time, and the technology has been worked on again for quite some time. So this process has been pretty smooth. And so because of that, it's already ready to be incorporated onto CRD. And a few states were able to test it last year as it was their first year, I guess this calendar year as it was their first year. So we are coming in with even more experience. So again, no extra steps for you. Yes, reach out to the course provider if that has not shown up in CRD for some reason. We won't be able to track that down and find out where the issue is, but you should be able to take a look at whatever courses you took, reach out to the provider, and then they can get that reported to FINRA if there is an error that's showing. As in terms of when the slides and presentation will be available, I do hope to post the presentation with this week, as well as the PowerPoint and the FAQs. But since it's Thursday and it does take quite a while to actually download this recording, the longer it gets and the more participants you have, it does take quite some time. So I would say within the next week. So I would check back by, I guess, the next Friday to make sure. And we do have that email list out there, so we can even send an email and let you know when the presentation has been posted and when the FAQs are on that website as well. And you can just check back. We will post it under the security section, so you'll be able to find it pretty easily. And hopefully we can post it on just that main page. When you just click on the KFI website, it should be very easy for you to find. But again, if you have any questions, reach out to any of us and we're happy to direct you to that. Let's see. And if anyone has any live questions, you're welcome to unmute and ask that question, and we'll do the best that we can. But again, please focus those on general information and not firm specific questions. So I have a question about CPA CE credits. So I really can't address that question because it just goes back to the approved providers. So one of the questions that I was specifically asked was about a CMP and some of that carryover or crossover between the two. And again, it just goes back to the courses. So if those courses that are provided, the provider provides a course to you as a CPA, as well as to meet these IAR requirements, then that would count. But I can't specifically answer in terms of the CPA and the IRCE crossover. So there is not a platform that I'm aware of that allows IRAs to communicate with each other. That's not anything that we can set up or anything that we have set up. Let's see. So are there any requirements with regard to in-person CE, or can all courses be taken virtually? And are there any self-study options? So virtual courses are fine. In fact, most are choosing to take all virtual courses. So there is no requirement that anything is in person. So you can accomplish all of that virtually. There are not any self-study options at this time because, again, these are specific approved courses that are done by a provider. And so the self-study option has not been made available. Lindsay, I have a question I want to see if you would address. Given the depth of information for creating these plans, is there going to be a template or an example of a plan? So, there's not going to be a template because, again, as Lindsay mentioned, this is really geared towards your firm, and every firm is uniquely individual. But I don't know if you want to give any tips or ideas that you do.
Probably from a compliance standpoint, we'll have like a checklist of at a minimum what we expect to see, which was kind of outlined in the presentation portion. But yeah, with the various services offered and the various business models, that we're not going to have develop, I don't think, a template necessarily, because it's really going to be more firm specific. So as I mentioned, though, we're not going to be coming out there and looking to take action on your firm because you don't have an adequate business continuity plan or cybersecurity policies and procedures. Yes, we will address any deficiencies we identify or provide you recommendations if we see vulnerabilities in your cybersecurity procedures, or we see something missing that we think is very relevant for your business continuity and succession plan. As long as you do those things and we, take into consideration those recommendations, then we won't take issue with that. But again, we're not going to be looking to take action and fine your firm because on this initial review, it's something we consider insufficient. So, but if you have specific questions, certainly feel free to reach out. And like I said, we'll kind of have a minimum standard and identify anything that we feel is missing from that.
So another question I have is regarding NASA and source of authority. So I just wanted to talk just a little bit about NASA and its relationship. So NASA is made up of 67 different jurisdictions from both North America and across the United States, Canada, and including Mexico. So it's a volunteer organization where we all work together, and we do create policies and procedures. We do put forth model rules for states to adopt. And this is something that the states all collectively kind of work together on. And so one of the questions I had was regarding authority. So NASA has no authority, and NASA is not does not control Kentucky's kind of policies or procedures or what we do. NASA is just simply a volunteer working organization. So any guidance that you would need does come from the state of Kentucky and will continue to come from the state of Kentucky. While NASA does provide resources, we have collectively worked on those resources with many other states. So again, NASA is not the authority. You would need to look back to Kentucky for any concerns that you have or any questions. And we make our own rules. NASA, again, does not make our rules. And again, NASA does not have any authority. We are absolutely working together to to do better and essentially for the industry and to provide more opportunities and more resources, just like with the IARCE. But again, if you have specific questions, you would need to reach out to the state of Kentucky. And NASA does have great resources for the IARCE, but you probably would want to start with us and then take a look at the NASA's website. And we're happy to answer any questions regarding cybersecurity or BCP or any other issues. But again, this does come from the state of Kentucky and what we have adopted. So I don't see any other questions right now that are pertaining to the topics. Oh, here comes one. Hold on. Let's see. So I can't specifically speak to any of the providers. You would need the reference NASA CD page, just on it. It does. You just need to take a look at it. Let me see if I can find it and I'll tell you where to go. But there are a list of CD providers that are on the NASA website. I believe it might be under the FAQs, but they are definitely there. And if you send me, Mr. Davis, if you email me directly, I can send you the link for that. So again, it's marnie.gibson@ky.gov, and I'll make sure that you're able to see that list of providers. Okay, I think someone else dropped in the chat. It is under approved IRCE providers. Insurance is another great question because there are some IRCE and insurance that does overlap. So again, lots of providers are starting to jump into this space and provide CE not only for securities, but also for insurance, for CFP, and then for the broker-dealer side as well. So I think you will start to see more and more providers that will offer courses that would fit. So does anyone have any additional questions? If you do, if you would just go ahead, you can put those in the chat now. And again, if you're not comfortable asking in the chat, or if you don't want to speak, you can just email us and we're happy to respond to those questions later. Lindsay or Chad or Anthony, do you have any closing commentary or anything want to add? I'm still looking for questions. I don't want to keep you on here forever to look at a blank screen. So we do appreciate everyone attending today, and we do hope that you found this helpful. And we will try to get the PowerPoint presentation, the FAQs, as well as this recording up by the end of next week. And again, as I mentioned several times, just reach out to us with questions, and we are more than happy to address those and do whatever we can, because we understand that these are new requirements. And we're here to help you through those and to make sure that you're in compliance, especially in terms of the business continuity planning, as well as the cybersecurity, because we know those are new. Our goal for you is just to, I'm glad your compliance officer thanks us. Thank you. So if you could just really recognize that we will be here to help and just have those plans in place, and then we will offer suggestions as we go through the exam process. IRCE, it's flexible in terms of your registrations, but you need to complete that. So go ahead, get started. You have lots of time, but we don't want to see anyone that is IRCE inactive at the end of the year, if that can be helped. So again, thank you all very much for your time. I'm going to stop the recording now and then just look for those presentations and reach out to us with questions. So thank you very much for your time today.
Great, thank you.